Good morning everyone, my name is Michelle. I hope you're doing well. Welcome to another video. It is Wednesday morning, the 15th of November. Why do I think that date is significant? 15th of November. It's 29 months since Summer Wells disappeared, which is tragic in itself. Anyway, we're going to talk about the Delphi case today. Again. We've got a new court filing, this time from Judge Francis C Gull. And you know what comes next? Oh yes, let's discuss. This is the filing itself. It's only just over a page long, but that's okay. Now, let's remind ourselves what this is in response to. It's in response to, although it doesn't actually say it's in response to, but it is. Come on, it is. To the first writ that Cara Wernicke and colleagues compiled on behalf of Richard Allen, that they have delivered to the Supreme Court of Indiana for action. So let's remind ourselves about what that first writ was. The Supreme Court of Indiana, State of Indiana, on the relation of Richard Allen, who is the realtor, to the Carroll Circuit Court and the Dishonourable Francis C. Gull. So the deadline that Francis has to respond to this writ is the 16th, so tomorrow. All right, we'll go down to the bottom just to remind ourselves what this requires, or what it's asking the Supreme Court to interject into, if that's even the right way to explain it. Realtors, that's Richard Allen, requests that permanent writs of mandamus and prohibition be issued. 1. Mandating that the trial court reinstate the following court records as publicly accessible documents on the court system and the electronic case file. The September 18th Frank's memorandum that she took off, that she sealed. Okay. All right. Well, she did something with it. So Richard's October 25th verified notice of continuing representation. That was the original attorneys, Brad Rosie and Andrew Baldwin, wanting to continue to represent him, even though she says that they withdrew. Okay. All right. I'd have to check the date, but I think that's Brad Rosie's. The October 25th motion to disqualify the judge. Okay. The request for the transcript from the October 19th in-chambers meeting, which Richard Allen didn't attend. October 26th motion for continuance. Okay. Number 2, prohibiting the trial court from ordering the removal of any court records filed in this case from the files, prohibiting the trial court from excluding from public access any court records without the requirements of the access to court records rules being satisfied. So every court record excluding from public access must be accompanied by an ACR form to say why it's been excluded. And then, unless everything in the court record can be properly excluded from public access, a public access version and a non-public access version of the document must be filed. 4. Mandating that the 118 documents on the zip drive must be made publicly accessible on the CCS itself. 5. Mandating the court records referenced in the June 28, 2023 order that remains excluded from public access by agreement be made available for public access 72 hours after the writ is issued, unless the requirements of Rule 6 are therefore satisfied. Mandating that the June 20th filing by Carroll County Sheriff and the July 5th 2023 letter from DOC, so Department of Corrections inmate, be made available for public access. All right. So that's what they wanted. Let's see what this supplies. The court has recently reviewed the chronological case summary in this cause and notes that the clerk of court has not yet made available to the public the 118 documents previously made remotely accessible by court order of June 28. Okay, so they're just reviewing it. Just, Frances has got a spare minute, and she said, "I know what I'm gonna be dead studious, and I'm gonna go to the CCS, and I'm gonna check." All right. So obviously, this is because of the writ. The court previously created a website for these documents. It wasn't really a website. There was a Google Drive, and I think it was available from another source, similar to a Google Drive account. I've got the Google Drive. It's not really making a website, but why they just couldn't have just made them available on the docket, I don't get it. But anyway, they've changed it, and the clerk is ordered to enter these documents on the CCS forthwith. As soon as you can. Do it, cracks the whip. Do it. The clerk is further ordered to unseal the June 20th filing by the Carroll County Sheriff and the July 5th letter from the Department of Correction inmate placed on the CCS. All right, so let's see how many we can tick off. So, tick. Got that one. Tick. Got that one. Tick. Got that one. We've got 3 out of the 6 things requested covered so far. So good. All right. The court further notes that the motion for Frank's hearing and accompanying documents filed by former attorneys on September 18th, including the Frank's motion, memorandum in support of motion and exhibits list. Now remember that in one of the documents, I don't remember which it was, but she said that she'd not got all the way through the documents yet. It's a 136 page, the memorandum itself, and then thousands of hours of everything else. That's funny. Okay. Are marked as confidential on the CCS as counsel failed to supply a redacted version at the time of filing. Well, that's new. So, did she ask them for a redacted version? And what needs to be redacted from it? I'm interested as to what needs to be redacted. I assume the names, like Brad Holder and Patrick Westfall and others, Elvis. Is that what she's referring to? They're arguing that Richard Allen is innocent based on third-party guilt. So, putting the names out there, isn't that necessary to make such a defence? And because it's saying that the search warrants of Richard's property and the seizure of some of his stuff was illegal because Judge Dina wouldn't have signed the search warrant had they not lied, and it's all kind of together with this, well, they've lied, but there's all these other people who are out there who are really guilty, but you've lied against our client. I don't know that the names should have been redacted. They're all adults. It's not like there's any minors in there. I would understand it if there was minors in there. I mean, it is something that has been done before, I've got to say. Like the first version of the PCA had all the names redacted. We've got all the names now. But that's stupid. Right, listen. Listen, Francis. The unredacted version is already out. You might say, well, yeah, because the defence filed it erroneously, made it public erroneously. I don't think that argument's solid, but you could have that argument if you wanted. But now, the entire thing the memorandum. I'd love to see the exhibits, but yeah, we've not got those. I mean, we've never had those. And some of those were filed confidentially. It says in the memorandum that they've been filed confidentially for, you know, appropriate reasons, like crime scene stuff. But it's in the Supreme Court of Indiana documents now. The full thing is there, unredacted. So, Francis, do you still have an argument about having a redacted version? And because you've not got a redacted version, you're not gonna make it available. All right. Okay. So you're not doing that. All right. On October 31st, the court ordered defendants' new counsel to review the pleadings and discovery and either adopt these pleadings or make their own. So are you going to go with the memorandum or are you going to make your own? Okay. If defendants' new counsel inform the court they intend to pursue the Franks motion, the court will schedule a hearing. So have you read it now, Francis? Have you actually done your homework now? Or are you hoping that they won't go with it? Do you already know? Do you already know that they're not going to go with it? That's why you can just say, oh, well, it's confidential. And, oh, well, yeah, we can have a hearing. Because, you know, your mate, William Labrator, that you appointed, you know, have you been sending little cute Facebook messages to him behind the scenes, have you? Okay. I'm not going to hold my breath that we're going to get a Franks hearing anytime soon. Finally, the clerk is ordered to place and make accessible on the CCS former attorney's pleadings of October 25th and October 26th. As noted in its prior order, the court considers those pleadings stricken from the record and will not consider these pleadings as the attorneys who filed same or no longer counsel of record. Okay. Well, that's interesting. So you're making them available, but you're striking them from the record. So basically, you're just not going to do anything about it. All right. So, you know, the motion to recuse yourself, you're just going to ignore that. All right. Because you have erroneously, unfairly, immorally disqualified two attorneys that the defendant, Richard Allen, wanted to continue with, because you didn't like them. That's basically what it was. You've still not made available the transcript. So where's the transcript? You've not done that yet. So you've not mentioned the transcript. But this was a review of the court system. So, yeah, they're just by chance that you went to review it. All right, okay. That's sealed. That's confidential because you don't like the fact that it's unredacted. All right, okay. But we've all got it because it's in the Supreme Court of Indiana package. So you're not going to do anything about that. You're not going to do anything about that. All right. You're not going to do anything about that at all. Transcript you've just ignored in your review of court documents. You've just ignored that. Watching you, Francis. You think you've got till the 27th to deal with that, don't you? Because it's in the other writ as well. Okay. All right. And then motion for continuance. So you're ignoring those because you erroneously, immorally, and you just decided to disqualify them with no evidence of gross negligence. You've not provided your evidence, and you've not given them the opportunity to bring witnesses to a hearing. I expect within the next 24 hours the Supreme Court of Indiana will produce something. Let's wait and see what they say. All right, guys. Let me know what you think in the comments below, and I'll see you in the next video. Francis, watching you.